Good morning, and welcome to Unfiltered Vision News, bringing you the news unfiltered Monday through Friday. Today is Mighty Men Thursday. Thank you so much for joining me here on Unfiltered Vision News. And we're going to start with our trending topics on X. The first one I wanted to get to is that I'm not sure people know the difference between culture and religion. And when I say that, right now, you have members of the religious Islamic community teaching their religion as if it's culture, and it's not. Now, it might be cultural to some individuals who come from Islamic countries, right? So I want to say that respectfully. If you are in a predominantly Islamic country, it may seem like that's the culture, right? Because it's so intertwined. Stop. Stop bringing that here. Your religious practices stay in your religious houses of worship, okay? Because, see, if children were on a playground singing Christian songs and parents were atheists, which it's happened, right? This is why people cry, there's the difference between church and state, and you're not supposed to bring in religion and all this other stuff, right? Right. Okay. So let's get into this. This first one. This is, look, you guys, you're gonna be like, what what is going on? Well, all of this is going on, so let's check it out. It says here, Brooklyn School, uh Dabke, hopefully I'm pronouncing that wrong, I'm probably mispronouncing it, dance sparks misunderstanding over culture. Now, is Islam a culture or is it a religion? Like, pick a lane. You don't get to do both. Because here's the thing. If it's culture, right? Okay. All right. I guess. Then you're not protected under freedom of religion, right? If it's culture, then we can just stop you. And we can say, nope, you're not doing that here. You're not doing that there, right? We can kind of refuse some things. But you can't say it's culture and then hide under religion. You got to pick a lane. That's all I'm saying. So a video from PS 107 in Park Slope shows kids watching a Debki perform a traditional Levantine folk dance celebrated during Arab American Heritage Month. So that's how they're turning Islam into culture, right? Under this Heritage Month. The school's PTA shared it as a highlight of rhythm and tradition, but critics like Bridget Gabriel called it indoctrination into Islam. Despite Debke's roots among Muslims, Christians, and others with no religious rituals involved. Johnny Kletter, head of the school's Jewish Affinity Group, noted upcoming Jewish heritage events, affirming the principal's support for all cultures in this diverse K-5 school of 350 students. Here's the problem. Stop intertwining your religious practices and calling it culture, because they're two different things. They're two totally different things. But here's Bridget Gabriel. She says, no American public school child should ever be forced to embrace Islam. This is indoctrination, not education. So let's rewind this short clip.
What is the name of this dance? Good job.
But anything that is involved in your religion is not culture. So stop that. Just stop. As Bridget says, it is indoctrination. It is. Now, if this were, Christian, people would be losing their lunch right now. They'd be like, oh my gosh, I can't believe you're doing this to children and you're indoctrinating them. And this is what's happening right now. It needs to stop. Now, if if parents want to take their children to a synagogue so they can learn about this on their own time, not on the taxpayers' time, not during school, then that is the parents' decision. But this should not be happening at schools. And I'm a disciple. I am a Christian. Right? And if you're stating that religious practices should not be in schools, then they should not be in schools. This is not cultural. I'm just stating the fact. Now, the next topic that I wanted to get into, it's kind of a hot topic. Louisiana is really on the map right now, and we're going to get into the Supreme Court decision that happened with Louisiana and the map changes and all that stuff. So this post as well, Orleans Parish Sheriff Houston just got indicted, 30 felony counts, over the 2025 jailbreaking by 10 inmates. The indictment alleges her office failed to maintain adequate prevention and then attempted a cover-up. DEI in action. Now, that's just in wokeness. That's their caption, but I wanted to play this video.
New Orleans, I'm Orleans Parish Sheriff Susan Hudson. I'm here with the hardworking women of this jail. We are in the jail today. Just want to assure the city that we did suffer a cyber attack this morning that did impact some of our systems, but we've isolated that, and the jail systems are on a separate server and they're functioning just properly.
Okay.
New Orleans.
All right. Yeah, so some of the indictments include alleged malfeasance, payroll fraud just days before her term ends. The indictment brought by the Louisiana office follows months of scrutiny into finances and operations at the jail. And it's really sad because a lot of these things keep happening, and they're happening with melanated humans, just saying, and some that aren't, and some that aren't. But I think at the end of the day, it's just the disrespect that's shown to the public, right? And just the constant, gosh, how do I say this in a nice way? It's just, how should I say it? There are some people that shouldn't be hired in certain places, but I think they're hired in certain places to be used, right? Not necessarily to do a good job, but to be used for other points and purposes. They're used for virtue signaling. They're used to make it seem like, see, we're not racist, we're not prejudiced, we're not discriminatory, we're not these things. But when you do that, sometimes you don't get the most qualified individuals. You don't, because you're playing this constant cat and mouse game. And that brings us to the Supreme Court decision with the 1964 Voting Rights Act. Now I want to set this up for you guys. And this is a question that I constantly battle with, because we live in a country where it says all men are created equal. All men, not some, not in particular, not based on your zip code. All men are created equal. However, we had a Civil Rights Act of 1866 specifically written for Negroes. And if you are not a Negro, then it doesn't apply to you. But what I find fascinating is that in a country where we said all men are created equal, we had to have separate civil rights because people were treated less than human being. Yeah. And I'm going to keep saying that till somebody hears me, because nobody ever asked that question, right? Because I guess if you're not a Negro and you're born on the soil, or you're from a certain lineage that's not a Negro, then the First Amendment applies to you, right? Where it says all men are created equal. It applies to you. That all men are created equal under our Constitution. But that doesn't apply to me, because I have a separate set of rights that were put in later, because people of my lineage were not considered human in a country that says all men are created equal. So no one can square that. No one talks about it. No one addresses it. Because, see, if all things are true, get rid of everything. Get rid of all this civil rights stuff. Get rid of all of it. Then nobody's jumping through hoops. Nobody cares about gerrymandering. Nobody's doing any of it, because the whole situation of race would be abolished. There would be nothing to fight over. Nothing. Nothing. If you're an American, you're American. If you're not, you're not. And that's it. That's it. You got two choices. You either are or you aren't. Done. Nobody's having these little sidebar conversations about race, because it wouldn't matter anymore. But you gotta have something to keep division. And I did the practice, of course, with my husband, because y'all know, I love him. Oh my goodness. So we did a little bit of a test. And he read a post off of Facebook about race. And I said, okay. And I did this. I said, white and Hispanic, how do you feel? And he was like, well, I don't know. I said, white and black. He was like, ooh. I said, yes. Because, see, we've been conditioned like Pavlov's dog, that whole theory, right? That whole theory, when you start it puts like somebody punched you in the gut in your stomach when you say black and white. And it evokes all these emotions and feelings and all this stuff. Just like how Freudian did his test with Pavlov's dog. How whenever the dog heard the bell, he would salivate because he knew it was time to eat. And just like when people hear black and white, it invokes all kinds of emotions, because they get upset about all the things that they've seen between the black and white race. That's why I say some people can't play the race game, because you don't have a race. You're an ethnicity. You can't play the race game. What are you talking about? But you want to get involved in the race game because it serves you, whatever purpose you're trying to do. And this is why, in my opinion, we need to settle this. Either we are or we aren't. We're Americans or we're not. Period. I don't care about your race. Either we are Americans or we're not. Because if we get it down to that, you're an American or you're not, some people are going to have to get up off soil, because they're not. You're not here legally. You're not an American citizen. You got to go. Because only those that are American citizens are going to be protected. Oh, and this gets us back to the movie Civil War, right? What kind of American are you? That part. Yeah. All right. So I wanted to check out this whole little situation with the Supreme Court. So let's get into it. So I'm going to read the syllabus for you guys. I'm just trying to get it set up here on screen. So when I read it, because we're going to go from the syllabus and then go down to where it talks about the opinion of the court and the ruling and all that stuff. And then there's dissenting opinions. I'm not going to read the dissenting opinions. We're just going to read the syllabus, kind of how this all came about. We're going to get into a little bit of the Bill of Rights, a little bit more opinion that I've got on this stuff. But let's go. Okay, so here it is. And this is from their term from last year going into 2026. So this was argued in October 15th of 2025 and was decided yesterday, April 29th, 2026. Okay, so this is an appeal from the United States District Court for the Western District of Louisiana. So these cases concern whether Louisiana's new congressional map. Let me make it a little bit bigger for you guys. I know. I can make it so big, and then if I make it too big, you can't see it on screen. Okay, yeah, that's much better. Okay. So these cases concern whether Louisiana's new congressional map is an unconstitutional racial gerrymander, right? So in 2022, after the state redrew its congressional districts, a federal judge in Robinson versus Erdoin 605 held that the 2022 map likely violated Section 2 of the Voting Rights Act of 1965, Title 52 U.S.C. Section 10301 et seq. Because it did not include an additional majority Black district. So again, we're playing the race game. But when the state drew a new map, SB 8, that contained such a district, the map was challenged as a racial gerrymander. Pick a lane. You say, okay, it didn't include it. Then when you included it, then it got challenged. Like, huh? Again, we need to get back to just being Americans. We really do. Now, ethnicity, completely separate conversation. Ethnicity is a completely separate conversation. We're talking about race right now. So a 3-judge court in Callis versus Laundrie, 732, supplemental 574, held that SB 8 violated the Equal Protection Clause of the 14th Amendment, and the state appealed this to this court. So you're playing the race game, and it's not working out well. That, in my opinion, that's what this comes back to. It all came back to race. It didn't have anything to do with how people voted or whatever, even though they might have said this is how people voted. You still got to have a majority Black states. Why? So I want to give you guys a picture of the map. So these are the maps that they're talking about. So this is what the map looked like in 2022, and this was the proposed map, 2024. This is what's being challenged right now. Okay, as you can see, they had 1, 2, 3, 4, 5, 6. But it's the way it's split out. So you've got these large chunks over here, large chunk over here, and a little bit over here, right here. So then they took 6 from down here and took it way through the middle. I was like, why would you do that? So that they could keep a Black majority, right? Because according to what they were supposed to be doing, if they got to have a Black majority, I'm like, what are you talking about? I know. So much back and forth. So I'm also going to include this in the link. It just says how redistricting works and the Legal Defense Fund and how you can get involved, which I think is weird, but this was around 2021 when we were talking about it. Okay. I gotta walk you through this because I didn't want to do it in Grok. I really wanted to give you guys the links and the research and just how my mind works around this and how I pull a lot of this stuff in to make it make sense. So Section 5 was designed to ensure that voting changes in covered jurisdictions could not be implemented are used until a favorable determination has been obtained. That's interesting. The requirement was enacted in 1965 as a temporary legislation to expire in 5 years and applicable only in certain states. So the specifically covered jurisdictions are identified in Section 4 by a formula. The first element in the formula was that the state or political subdivision of the state maintained on November 1st, 1964, a test or device restricting the opportunity to register and vote. Okay, the second element of the formula would be satisfied if the director of the census determined that less than 50% of persons of voting age were registered to vote on November 1st, 1964, or that less than 50% of persons of voting age voted in the presidential election of 1964. Application of this formula resulted in the following states becoming in their entirety covered jurisdictions. Okay, so those are some of the formulas. Those are some of the litmus steps. So Alabama, Alaska, Georgia, Louisiana, who's in the hot seat right now, Mississippi, South Carolina, Virginia. In addition, certain political subdivisions, usually counties, in 4 other states, Arizona, Hawaii, Idaho, and North Carolina, were covered. It also provided a procedure to terminate this coverage. So it was supposed to expire in 5 years. So if it's supposed to expire, that would have been like, what, 1969? But we're still messing with this stuff. We're still messing with it. So I wanted to just dig a little further. So, some people may know the history of the Voting Rights Act, some might not. So it was signed into law in 1965 by Lyndon B. Johnson. It was a landmark civil rights law designed to enforce the 15th Amendment, outlawing discriminatory practices like literacy tests and poll taxes. It aimed to end racial discrimination in voting, particularly in the South, triggering a surge in minority voter registration. Again, I go back to my initial point. If we are in a country where it says all men are created equal, why aren't we? Period. We have all of these separate laws to make people whole, but at the end of the day, these same laws, policies that were written to abridge and help, right, for the most part, Negroes in this country be made whole, be seen as human beings, has been completely taken advantage of in a bad way. In a bad way. I'm just saying. So I wanted to just look at the language part, right? Because you can see, it did say that there were certain parts of the language. So it says Congress hereby declares, and this is language actually in the Voting Rights Act in Section 4. It says Congress hereby declares that to secure the rights under the 14th Amendment of persons educated in American flag schools in which the predominant classroom language was other than English, it is necessary to prohibit the states from conditioning the right to vote of such persons on ability to read, write, understand, or interpret any matter in the English language. So this is where we get individuals who aren't from this country. They're given translators, and they are given the ability to vote, even if they're not naturalized citizens. And people go, well, they can't vote in our elections, but they are. But they are. Because see, a naturalized citizen actually does have to read, write, and speak English. That's actually a part of how they become citizens of this country. But this was actually written for individuals who had to be made whole. Again, I go back to the Negro, who all they had to do was say, the Negro is thereby a citizen of this country. Never ever says in any documentation that Negroes were citizens. It just said you couldn't harm us. It just said that we had civil rights. Never made us Americans. Weird, huh? Yeah, that's for another, for a totally different podcast. For a totally different podcast. But let me keep going. So here is the Voting Act. Basically, it said, and the title of it was a Senate Bill 1564 under the 89th Congress, an act to enforce the 15th Amendment to the Constitution of the United States. So basically, these are the Voting Rights Act of 1965, so that Negroes specifically, I just find it crazy because it even says here, no voting qualification or prerequisite to voting or standard practice or procedure shall be imposed or applied by any state or political subdivision to deny or abridge the right of any citizen of the United States to vote on account of race or color. So you can't deny anybody on race or color, even though our Constitution doesn't talk about really race or color until it got amended to include people, race or color. Never, yeah, it says citizen, okay. So I guess we're citizens, so yeah. Are we? Again, I have to keep questioning it and going back to it. It's like, y'all, there's some things we're just gonna have to go back. we're just gonna have to revisit some things. I'm just saying, because I have questions. I have lots of questions. So the Bill of Rights, right? First 10 amendments and the Constitution, particularly the Supremacy Clause, Article 4, Clause 2, strictly prohibit Congress and state governments from passing laws that infringe upon fundamental rights. These include freedom of speech, religion, press, assembly, and protections against unreasonable searches and excessive punishments. Okay. That's what it's supposed to do. That's what it's supposed to do. So this is how it's supposed to work. And then I outlined it here again. First 10 amendments, right? Congress shall make no laws limiting freedom of speech, press, religion, assembly, on and on and on. Then I wanted to bring up this map. Now, this is the Louisiana map, but this is the Cancer Alley, right? And the reason why I wanted to bring this up, because when you look at this map and these areas here, they still fall within Cancer Alley. So they took it because Cancer Alley is kind of like right here in the 2 and the 1, but they took this and, took it up through the state to make sure that there was Black majority. Okay. Now I wanted to bring up this bill because this bill was read, but it was never passed and it was never implemented. It just wasn't. So it was to maintain the freedom of the inhabitants in the states declared an insurrection and rebellion by the proclamation of the president on the 1st of July, 1862. So at this point, Abraham Lincoln is still alive. Being enacted by the Senate House of Representatives of the State of America, the United States of American Congress assembled that all laws, statutes, ordinances, rules, and regulations of any description whatsoever herefore in force or held valid in any of the states which were declared to be in insurrection and rebellion by the proclamation of the president on the 1st of July, 1862, whereby or wherein an inequality of civil rights and immunities. Now, this was 1862, so the civil rights didn't come into play until 1866, but here we are. Among the inhabitants of said states is recognized, authorized, established, and maintained by reason or in consequences any distinctions or differences of color, race, or descent, or by reason or in consequence of previous condition or status of slavery or involuntary servitude of such inhabitants be and are hereby declared null and void, and it shall be unlawful to institute, make, ordain, or establish in any of the afford states declared to be in insurrection or rebellion any such law, statute, act, ordinance, rule, or regulation, or to enforce or to attempt to enforce the same. In essence, you can't put in laws that make it hard for people that were formerly enslaved. So you can't do it, right? They're free people. You cannot, under the state, harm them. Basically, that's what that says. And it says, be it further enacted that any person who shall violate either of the provisions of this act shall be deemed guilty of a misdemeanor and shall be punished by a fine of no less than $500 nor exceeding $10,000, and by imprisonment not less than 6 months nor exceeding 5 years. And it shall be the duty of the president to enforce the provision of this act. Interesting how they put it in the hands of the president. They didn't put it in the hands of Congress. They didn't put it in the hands of the actual state. They put it in the hands of the president to enforce this, that the states couldn't harm people. Because see, we had Jim Crow, we had redlining, we had all these horrible things to the point where they had to put in a Voting Rights Act. That's why I wanted to do what I just did, to show you. Yeah. Slaves, people, slaves, Black, Negroes, Negroes in particular. Negroes were not considered human, and they needed laws to literally make them human in a country where all men are created equal. So thank you guys so much for joining me here on Unfiltered Vision News. And remember, stay well, stay focused, and stay unfiltered. We'll see you in the next one.